Recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Madam Attorney General, the central issue to me is this perception, frankly rooted in some realities of a dual-track or two-tiered justice system. And I know that you have dedicated your career to the pursuit of justice. I know you work for a blindfolded woman who's holding nothing but a set of scales. And I think it's important that she's blindfolded because she shouldn't see the race, the gender, the socioeconomic status, the fame or lack of fame of the person in front of her. And I'm sure you've experienced it like some of the rest of us. It's not just the suspect or the target or the defendant. The witnesses have to have confidence in the justice system. The jurors have to have confidence in the justice system. The public has to have confidence in the justice system. So this dual track, different set of rules for certain people than for others. It frankly should not matter whether you are running for president or running late to a kid's ball game. The same rules ought to apply to everyone. So let me ask you this. Why do you think it's important to use official email to conduct official business?
I believe it's important to do that. I think that certainly every department has chosen to craft the way in which they carry out their business, and it provides for a way of doing business in a secure system.
So you use official email to conduct official business?
Yes, sir, I do.
Okay. And do you ever email, send or receive classified information on personal email?
I do not.
I doubt you even use your USDOJ.gov account to send classified information, do you?
We have separate systems.
Right.
So there would be a separate
classified system
for that.
Right. So not only do you not use personal email to do it, you don't even use your USDOJ.gov. You have a separate dedicated system to handle classified information. Why?
We have a separate system to handle the security needs.
But my question is why? Why is it important enough to you to not use personal email to conduct public business and to use a separate, more safely guarded system when you do handle classified information?
That is the practice that I've certainly always followed. It allows for the protection.
I mean, it's not just a personal preference, is it?
No, it allows for the protection of the information, both on a regular system, because again, that's still sensitive, law enforcement types of matters, and then a classified system for separately classified information.
What element do you think was lacking in the statutes that you evaluated as it relates to Secretary Clinton? So
let me, again, as I've indicated before, and I want to make it clear that as I indicated before, while the reason why I will not be going into the analysis that was provided and the discussion that we had between myself and the team is because we protect our teams and that they have to be free to provide information and analysis in a confidential way without the fear or impact of there being a political influence on that.
I understand
and that is why
that.
I have not gone into that type of discussion. What I can tell you is that the team did evaluate the relevant statutes that were considered in this investigation. They looked at all of the facts and evidence, and as in every case, they applied them to that statute to determine whether the elements had been met. But my specific question to you, Madam Attorney General, is what element of which offense did you find lacking from an evidentiary standpoint? Well, I would say that in order to answer that, I would have to go into the entire level of analysis.
Well, don't you think public perception in a single-track justice system is important enough that you could at least touch on what you thought was lacking?
Congressman, in this case, we have taken the unusual step of discussing it in ways that the department typically does not, in order to provide more clarity into this situation. And while I understand that it is frustrating to a number of people, civilians as well as members of this body alike, we have taken extraordinary steps to discuss this matter in ways that typically we do not,
Let me ask you this.
When charges are not brought. And as I indicated before, just so it's clear, my reasons for not going into the substance of the information that I receive and review before I made my decision to accept the recommendation are that the teams that I work with, whether it's this case or any other, be free to provide confidential analysis, discussion, without the input of any
All due
kind of
respect, Madam
political
Attorney General,
influence.
you can do all of what you just described and still tell the people what element. I mean, the elements of a criminal offense are public, so there's no secret there. And for you to go through the elements and say, as Director Comey did, he said there was no specific intent. I'm out of time, but I suspect you have prosecuted reckless homicide cases, haven't you?
In the context of violent crime.
How about involuntary manslaughter?
For the department or personally?
No, just as a prosecutor. There's involuntary manslaughter, there's reckless homicide, there's felony DUI where you really didn't mean to hurt anybody. You really didn't, but you did. And this lack of specific intent is not a defense in any of those cases. So I think the public would like to know how you determined she did not have the intent to break the law and why you are applying a specific intent requirement here when you don't even do it in certain homicide cases.
Well, Congressman, as I've said, I think you've mentioned a number of state cases there. But as I've said, the reason why I am not going into the discussion I had and providing that particular level of information, although the FBI director did choose to do so, is that the information the team provides to me on this or any other case has to be given in a zone of confidentiality so that they can be clear and sure that there's never a political overtone to their decisions, nor will I apply one in accepting their decisions. That's why we have taken the unusual steps of providing greater information, as frustrating as that has been for a number of people to have additional information. That's why I took the unusual step of clarifying my role in this investigation.
Well, I'm out of time. The only thing I find frustrating is that even after this and Director Comey, people still believe that if you are famous, there's a different set of rules than if people don't know your name. And I think you're missing a wonderful opportunity to say with specificity which evidentiary element you found lacking. So Congress can go fix the statute if you think we need to, but right now, we have no idea whether or not a President Lynch could do exactly what Secretary Clinton did, or whether President Clinton could do exactly what Secretary Clinton did. And I think that lack of clarity is bad for the Republic, quite frankly. I thank our witness. Mr. Horowitz, you had a very distinguished career as a prosecutor in the Southern District of New York, so I will see if you can help me work my way through a quote. And it's not a quote from you, so it may be problematic for you to help work our way through it. The quote is, federal prosecutors will have to close cases and let those criminals go. That is a quote from the President of the United States with respect to sequestration. And I'm wondering who he is talking about, those criminals, because if it's an open case in a U.S. Attorney's Office, we typically refer to those folks as defendants as opposed to criminals, don't we?
That's correct. If it's a charge case, they're a defendant.
So who are those criminals that the President was referring to when he was invoking the Hale-Bopp comet apocalypse talking about sequestration? Do you have any idea who those criminals would be?
I don't, Congressman.
I think your former colleague from the Department of Justice testified that if sequestration were to go into effect, it would take us back to 2009 funding levels. Did I hear the testimony correctly? Yes, sir. How many criminals were let go in 2009?
I'm not aware of criminals being let go. I wasn't in the Justice Department at the time.
How about the gentleman from the Department of Justice? Any criminals let go in 2009?
That's not something I can answer this morning, sir.
Well, I think we would have heard about it if a bunch of criminals were let go due to a lack of funding, don't you? I mean, we would need a congressional hearing for that. We would have all heard about that.
The resources that are provided to the United States Attorney's Organization influences the staffing and the prosecutors and the paralegals we have.
Well, I know that, actually, and we had furloughs in South Carolina. We had to furlough prosecutors. We had to furlough victim advocates. We had to furlough administrative assistants, investigators. Not a single solitary criminal case was closed because of those furloughs. So what I'm trying to get at is the irresponsibility of threatening, whether it's the Attorney General saying we're going to be less safe or the President saying we're going to let those criminals go because we can't survive on 2009 funding levels. So when sequester went into effect, the net result, the net impact on DOJ's budget was what, about $100 million?
The net impact of sequestration was $1.6 billion this year.
No, I'm talking about salaries and expenses. The salaries and expenses, because that's what would impact whether or not cases had to be closed and criminals let go, is about $100 million.
I would have different numbers than that. I'm not sure.
Well, let's assume for the sake of argument that I'm right. Just assume arguendo I'm right. Are you telling me there's no other place to save $100 million within DOJ's budget?
Our problem is we have to save $1.6 billion, and that will be comprised of both.
I want to focus on the U.S. Attorney's Office, that line item, salaries and expenses. Because the quote was, cases are going to be dropped and criminals are going to be let go.
From a chief financial officer perspective, this is the way I would look at the issue that you're raising this morning. When we take the sequestration cut to the U.S. Attorney's organization, you're right, they have the ability, and frankly, they're going to have to look at taking cuts across the spectrum of their budget. That includes their personnel, their salaries, and their benefits.
What is a SALSA? What is a special assistant U.S. attorney?
What's a special assistant attorney?
Yeah.
That's an ordinary prosecutor is known as an assistant United States
right,
attorney.
and a special would be a state prosecutor that maybe was on loan, or in some instances, some folks just volunteer to work for the U.S. Attorney's Office for the experience, and they do so for free. Agreed?
Right. You can have a special AUSA.
Okay. And they would be free in some instances.
They could be.
All right. How much did you spend on conferences last year?
How much did we spend on conferences last year? About $54 million, approximately.
And how many of those conferences were for CLE credit that could not be gathered any other way than attending a conference?
I don't have that information at the table with me. We'd have to get back to you.
Can you get CLE credit so you can keep your law license via the internet?
That I don't know.
Well, you can.
No.
So,
Gentleman's time has expired. The gentleman from Virginia, the chairman.
The gentleman from South Carolina.
thank you, Mr. Chairman. Just initially, I wanted to make the observation, Mr. Chairman, according to the pre-sentence report, Mr. Beal is looking at between 30 and 37 months in federal prison for about a $900,000 loss. You get more time in prison for that, for stealing a six-pack of beer if you threaten that you have a weapon, which you really don't have. You get more time in prison for that for a very small amount of certain controlled substances. Even though he refused to answer our questions, Mr. Sullivan, did you interview Mr. Beal?
My staff did, sir.
Did you advise him of his Fifth Amendment right?
At the time of the interview with him, it was with counsel, it was in the U.S. Attorney's Office or proffer, and that was not necessary. Per written agreement, he would cooperate with us.
All right, so you had an agreement with him that he would cooperate. Did that agreement also include that he would cooperate with other entities that were investigating wrongdoing?
At the time, the agreement was the proffer meeting, and it was up to the U.S. Attorney whether he would accept it or not. So it was a limited agreement.
He's getting a 3-level reduction in his guideline range for cooperation. That's super acceptance of responsibility. And yet this morning, he wouldn't answer a single one of Chairman Iss's questions. So I guess my question is anyone going to go before the district court judge and make sure he or she knows that Mr. Beal wouldn't even answer this branch of government's questions? He answered you can't plead guilty without waiving your Fifth Amendment privilege. So he waived it for the judge, and he waived it for the executive branch when you wanted to talk to him or when the U.S. Attorney wanted to talk to him, but he wouldn't waive it for Darrell Issa when he wanted to talk to him. Well, can I rest assured that the
the sentencing judge will be made aware of that?
Well, what we will do, Mr. Gowdy, is we will brief the U.S. Attorney, AUSA, on the case, and we'll bring your concerns forward to the U.S. Attorney assigned to the case.
Yeah, I just find it stunning that you would want to avail yourself of the maximum departure from the guidelines that you can get for acceptance of responsibility and still sit here and not answer a single solitary question from a co-equal branch of government. Ms. Maloney asked a question that I thought was an extremely good question. Actually, she asked a bunch of really good questions, but I never heard an answer to this one. Is there a policy or procedure in place to investigate conflicts of interest between those who approve bonuses and those who receive bonuses? Not all at once.
The only requirement I know of, Congressman, is a financial disclosure requirement of all the senior officials.
So in theory, Mr. Brenner could be approving financial bonuses or other financial incentives for someone that he has a financial stake in whether or not they get more money. Is that within the realm of the possible? Because it certainly sounds like that's what went on.
Well, I'm not going to speculate on what's possible, but...
Why not?
Because I'm going to wait to read what the IG investigative report.
Well, if you're not going to speculate on what's possible, my next question is this. If Mr. Chaffetz or Jimmy Jordan told Chairman Issa that they weren't going to be here for a couple of weeks because they were CIA operatives, how would Mr. Issa go about verifying whether or not, and I'm going to be very clear, to date, neither Mr. Chaffetz nor Mr. Jordan have alleged that they're CIA operatives. But if that were to happen, how would Mr. Issa go about investigating whether or not that was true?
I can't answer that.
Well, the next person who claims it at your agency, how will you go about investigating whether it's true?
Under the current rules, as Mr. Sullivan pointed out, if there's an interagency relationship with that agency, the general counsel and the head of the agency would know.
So, what, a phone call?
I don't know what the problem
is. That what we're talking about, Mr. Sullivan? A phone call to verify whether or not someone really is a secret agent with the CIA?
Well, I testified earlier, sir, that in 2008, a new directive came out, I think it's Intelligence Directive 304, which requires the Director of National Intelligence to inform the head of an agency and the agency's general counsel if one of their employees is working undercover for the CIA.
Mr. Sullivan, I appreciate that. And it really doesn't matter whether you're a new Earth guy or an old Earth guy, but 2008 just seems a little late to be figuring out that with one phone call you can decide whether or not someone who's claiming to be a spy and traveling first class and racking up $900,000 in unwarranted compensation really does work for another agency. I mean, look, I understand technology has progressed a lot. 2008 just seems a little late for us to figure that out. There was nothing in place prior to that?
Well, sir, clearly the officials at the time, going back to the 90s through the 2000s, could have checked his story. No one did. It took us in the IG about a week, using our contacts at the CIA, to positively confirm he had absolutely no relationship with the CIA. We were able to determine early on he's never had a security clearance. So right now, I mean, and when he was an employee, he was not allowed to see classified material because there was no security clearance on file with the EPA Office of Security.
I thank the gentleman. I just want to hear one more time. Since 2008, the head of each agency is given a list of anyone who is a clandestine agent working under their cover.
That's my understanding, Mr. Chairman, from Intelligence Directive 304. It's on the Internet. And it pretty much explains that the requirement of the Director of National Intelligence and the CIA to inform executive branch agencies.
So Secretary Clinton would know everyone at the State Department, and her deputy would know everyone who was CIA implant. The EPA directors, each of them, or administrators, each would have been given this information. So if the administrator had even one person who was embedded, they would know that. We don't need to know if they have one, but if any agency had an embedded CIA person, they would have, in fact, had a list, and he would not have been on it since 2008.
That's right. That's my understanding, Mr. Chairman.
Well, I share with the gentleman from South Carolina his outrage, but 2008 was a long time ago, too. I seem to remember George W. Bush was president then.
I defer to the Chairman's recollection.
With that, we go to the gentleman from Maryland.
Dawkins, I understand that Mr. Beal's fraud
Thanks, the gentleman from Illinois, and recognizes himself. It strikes me that there are at least two issues at play, two major issues. Number one is the efficacy of the ARB process itself, whether or not it is in our best interest to allow any entity to essentially grade its own papers. We don't do that in any other category of life. We don't get to sentence ourselves when we're in court. We don't get to grade our own papers in a classroom. The other aspect of the efficacy of the ARB is who they interviewed and who they didn't interview, whether or not they have to accept recommendations or don't have to accept recommendations. That's a separate issue to me, is whether or not the ARB process works, whether or not it has shortcomings. The second issue is, let's assume arguendo that the ARB process works. Let's just make that assumption for the sake of argument. Is anyone following the recommendations of the ARB? So, Mr. Secretary, I want to read something to you. We are disturbed at the inadequacy of resources to provide security against terrorist attacks. We are disturbed at the relative low priority accorded security concerns, and we praise the ambassador for seeking security enhancements long before the attack. Do you know what that comes from, Mr. Secretary? What I just read?
I believe it's part of the Accountability Review Board report.
From 1999. That was
Bushnell and Nairobi, correct?
That was the ARB from 1999, and you can lay it almost perfectly over what happened in Benghazi. And one other point, the 1999 ARB made it really clear. They went out of their way to make it clear. They were disappointed that the recommendations that came after the bombings in Beirut were not being implemented, something called the Inman Commission. So the 99 ARB criticizes existing State Department employees for not following the Inman Commission from 14 years prior. That is a quarter century's worth of recommendations. And yet here we sit. So what I want to do, because I honestly commend Mr. Schiff. It was a wonderful idea, and I thank each of you for coming. But giving the inescapable interconnectivity between recommendations made after Beirut and after Eastern Africa and now after Benghazi, we're going to look at some of those past ARB recommendations. And I'll give you one, Mr. Secretary. For diplomatic buildings abroad not meeting Inman, of course, Inman being, again, Beirut bombing, not meeting Inman standards, essential physical security upgrades should be made immediately. That was the recommendation of the 1999 ARB. Mr. Secretary, I'm going to read you another one. This goes to Mr. Cummings' point, which I thought was a wonderful point. Diplomatic petitions should be made to all governments with whom we have relations to remind them of their obligation to provide security for our embassy. Who in Libya were we to call? Who? Mr. Cummings' point is a wonderful point. It was so good the 1999 ARB made the recommendation. Make sure the host country is aware of its obligations. Who did we call in Libya?
Question, sir?
Yeah, when I pause, that's generally an indication I'm waiting on you to answer, but I'll make it more clear in the future.
I think this is the heart of the question. There are times when, for the national interests of the United States, we are going to have diplomats humanitarian programs, rule of law programs, and other things in places where the host country does not have a government.
Mr. Secretary,
And in those cases, we must take the lessons from this ARB.
was there a
and
government
previous
in
ones.
Libya for us to contact?
No, not at that time.
All right. So that recommendation of the 1999 ARB, we were not able to do. Let's move to one that perhaps we were able to do. This was also a recommendation from the 1999 ARB. And again, the ARB is presented to us as a panacea. I mean, that's the evolution of what happens, is there's an attack, there's a blue ribbon panel, we're going to study it, we're going to make recommendations, and this is never going to happen again. So back to the 1999, the Secretary of State should personally review the security situation of diplomatic facilities, closing those which are highly vulnerable and threatened. Why do you think the 1999 ARB went out of its way to use the word personally?
No comment, sir.
What is the answer? Privileged? I mean, that's a recommendation from the 1999 ARB. The Secretary of State should personally review. And I'm asking you with all due respect, we're not going to get to the word review. We got to get past the word that modifies review, personally. Why did they think it was important that the Secretary of State himself or herself personally review?
I think ultimately the Secretary, who bears the responsibility for the security, has to be brought the information that is necessary for him to make decisions.
Right.
That is my job.
Okay.
I have gone to the Secretary of State on different occasions, and we have talked specifically about the security of different places. Tripoli was one of them in particular since I have been back. But we have also looked at Sana'a. We've talked about Kabul. We talked about the other locations as well. Where I have concerns about the safety and security of our personnel, and if I believe that we are not doing the things that we need to do, then it is my responsibility to bring it to the Secretary.
And I appreciate that, Mr. Secretary. Was it done on September the 10th of 2012? Was it done prior to Benghazi? Because this recommendation has existed for more than 10 years.
I was not here at that time. I'm sorry. I cannot tell you.
Well, your answer mirrors what the 1999 ARB further said, which is, first and foremost, the Secretary of State should take a personal and active role in carrying out the responsibility of ensuring the security of U.S. diplomatic personnel. Is that being done now, and was it being done prior to your tenure?
In the time that I was here previously, and I have served under multiple Secretaries of State, I have heard every secretary talk about the importance of security. Okay. I have heard every secretary state to the personnel of the department that security is their function. Their personal security has to be their function. That goes from Madeleine Albright, that goes through Secretary Clinton, Secretary Rice, and with Secretary Kerry, who has also made those statements and has made statements that the safety and security of our personnel is absolutely one of our highest priorities.
And I appreciate that, Mr. Secretary. But again, I think words have consequences and they have meaning, and most people use words intentionally. And the 1999 ARB intentionally used the words personally and active. That, to me, does not mean talking about something. A personal review is not simply talking about it. Is the personal review ongoing? Is that ARB recommendation still accepted, I guess is my question. Does the State Department still accept these recommendations from the 1999 ARB, and is it being done?
Yes. I think the best and clearest example that I can give you today is a new process that we put into place, the VPVP process, the Vital Presence Validation process, where we, again, look at what are our vital national interests and why should we be in these high-threat, highest locations. We put this process up, and it goes all the way to the Secretary.
All right, and that is a great point, which leads very nicely into the next point I was going to make or ask you about. What is it about that recommendation that is so talismanic that it couldn't have been made prior to the attack in Benghazi?
I think the Department of State has practiced risk management from the day that
With
I
risk
came.
management being, we're going to weigh the risk of being somewhere with the benefits of being somewhere. We know the risk of being in Benghazi. Can you tell us what our policy was in Libya that overcame those risks? In other words, why were we there?
These questions, I think, have been fundamental to the department for over 30 years. It is the reason why in many places we have evacuated, or we have shut down operations, or we've taken our families out, or we've gone down to essential personnel only, or we've asked for Marines to come in and support us while we're there.
Right, and my point being, Mr. Secretary, none of that was done in Benghazi. So we know the risk in Benghazi. My colleagues and you and others have done a wonderful job of highlighting some of the tripwires, I think is the diplomatic term. What policy were we pursuing in Libya that was so great that it overcame all of the tripwires and all of the risk?
Not being here at the time, sir, I cannot answer that question for you. I do believe, personally, from my time at the United Nations, that many of us understood that if we lost the eastern half of Libya, that if we lost the confidence of the people after the revolution in Libya, that we were going to pay a terrible price. And I don't want to put words into Chris Stevens' mouths. I think he was an immensely talented diplomat, and I was not here at that time. But I think it was clear in Chris's mind why he needed to go to Benghazi and what he was trying to accomplish. I think today we have more formalized processes to make sure that those decisions are documented. The VP process makes us go through a process that I don't think was there prior to Benghazi. I think the results of the Accountability Review Board and the Best Practices Panel and the recommendations that we've accepted ensure that as we go forward, we've got a clearer, more precise, more mandated process for risk management. But I would tell you, sir, that every single day for the years that I was with the Department of State, we were weighing the safety and security of our personnel versus what our national security priorities were. And I think that's a fundamental tenet that you will find that everybody in the department agrees with.
Well, I appreciate you bringing the hearing towards its conclusion back to Chris Stevens and back to the other four who lost their lives. But Mr. Stevens was equally clear that he needed help. He was equally clear that the situation was getting worse in Benghazi. He was equally clear in asking the people who sent him there to represent us to provide adequate security, and none was forthcoming. With that, I would recognize the ranking member for his closing remarks.
The gentleman from Tennessee, who I owe a recognition to, is now recognized.
Thank you, Mr. Chairman. First of all, I'd like to remind members that the EPA, which is the law most under attack for all these opprobrious regulations, was President Richard Nixon's #1 legislative accomplishment. Secondly, I'd like to suggest that when I look at a map here of the states that recognize Tennessee's concealed carry law by reciprocity, most states already do it, but the states decided. They didn't have the federal government tell them to. The big state that doesn't stands out, big old pink state, is Texas. I don't know what your problem is. We brought some guns down there in the 1840s and helped you all out a lot. You all should remember that. But now, yes, sir.
I think it was 1836, but...
Well, it was within the margin of error. Tennessee requires a person to be 21 years of age to get a gun permit. Some states don't. You just have to be 18. Does it make sense to say to the states that require you to be 21 that you can have 18 and 19 and 20-year-olds now coming into your state with guns? I submit not. My friends on the other end of the side of the aisle are great supporters of states' rights until this happens. It's as if somebody's holding a gun to your head. I don't understand it. I'd yield back the remainder of my time.
Thank you, Mr. Cohen. The gentleman from South Carolina, Mr. Gowdy.
I thank the chairman, and the gentleman from Tennessee raised a very good point. I would be curious whether or not he agreed with me that there's a constitutional right to travel.
I don't know that there is. I think there's a constitutional right to, there's speech, there's redress your grievances, petition your government, freedom of religion.
You do not think the Constitution, within the penumbra of any
It
of
probably does in penumbra. I just can't place a specific case or a specific verbiage.
Do you think inherent within the Constitution is a constitutional right to defend yourself?
I guess there is. I don't know if it's in the Constitution. You have a right to liberty in the pursuit of happiness, and maybe defending yourself allows you to have happiness. Liberty is maybe there. Of course, that's a Declaration of Independence. I don't want to get like Governor Perry. I'm sorry.
Well, the gentleman from Tennessee is an extremely accomplished, highly decorated attorney who I have great respect for his legal acumen. But I guarantee you that no one on the other side of the aisle would allow there to be any restrictions whatsoever on the First Amendment. You would go nuts if we argue that states' rights allowed South Carolina to somehow impact the First Amendment. Or the Fourth, that we were going to have all these different search and seizure requirements based on the 50 states. Or the Fifth, that Miranda was going to be subject to what South Carolina wanted, or Utah wanted, or Nevada wanted. Or the Eighth with cruel and unusual punishment.
Would the gentleman yield?
I am just curious why the Second Amendment is afforded so little.
Would the gentleman yield?
If what you're saying is that the Second Amendment,
the gentleman from South Carolina has the time.
Would the gentleman yield?
Sure.
First of all, I don't think anybody would say that the First Amendment, the Fourth Amendment, or any of these other amendments are absolutes. There are limits on all rights, as the Supreme Court has said.
What restrictions would you allow the state of South Carolina to put on the First Amendment?
Well, the state of South Carolina can certainly have libel laws. The state of South Carolina.
Not that Trump, New York versus New York Times.
No, of course not. The Supreme Court, in our system of jurisprudence, despite what certain former member from Indiana thought, can
we require a test before you become a blogger? Can we require a test before you become a blogger to make sure that you would be a responsible?
If the gentleman would yield, let me answer the question. No, but the Supreme Court has delineated the legality of various limitations. The classic one, of course, is Justice Holmes' formulation: you can't cry wolf. You can't cry fire in a crowded theater. Unless, of course, the state says, yes, you can. But if the state says you can't, the First Amendment doesn't give you the right to do so.
My point is Heller said the right to keep and bear arms is a fundamental constitutional right that should be afforded the exact same amount of respect as all the other rights in the Bill of Rights. And we would never allow this I won't use the word that comes to mind. I can't judge motives. I was going to say charade, but I won't. We would never allow any other amendment to be subject to what we've been doing for the last 2 years.
Well, if the gentleman would yield, no. We allow, that's not the case. We allow other amendments to be subject to reasonable limitations, and the courts obviously delineate how far you can go.
There's a national standard with respect to the Fourth Amendment. There's a national standard with respect to the Eighth Amendment.
But even within those national standards, there is some leeway for states.
What state can disregard Miranda?
You can't disregard Miranda,
which state cannot give an attorney if you are facing a felony charge?
Say again?
Which state cannot afford you counsel if you are facing a felony charge?
There are certain things that states cannot do, obviously, but there are other things that states can do. States can have, for example, libel laws. How far you can go, the Supreme Court rules. States can have laws against, states have laws on searching vehicles, for instance, which the courts have declared do not violate. I disagree with some of those, but the courts have declared do not violate your Fourth Amendment rights. And the courts, frankly, have gone farther in giving the states...
States can give more rights than are what afforded by the
that's not what we're talking about.
But they can't give less rights.
No, but defining how far those rights go is what the courts do.
Well, I guarantee you, if this were a conversation about what limits to put on the First Amendment, you would be apoplectic. If we were going to require tests, if we were going to subject the First Amendment to the same scrutiny that we do the Second Amendment, there would be apoplexy on the other side of the aisle. And I am just curious why the Second Amendment is afforded so little deference.
Mr. Gowdy, would you yield?
I'd be delighted to yield to the
The
gentleman.
gentleman's time has expired. The gentleman has yielded an additional minute.
Yes, sir.
Thank you. Are you submitting that there should be a national right to carry law and that the state laws are violative? Because if you have state laws that limit who can have a gun, that they are in essence violations of the Second Amendment, because the Second Amendment says everybody should have a gun.
What I'm asking is why we have a national standard for every other amendment except the second.
Well, we don't have necessarily...
Because I have been getting, some of it good-natured and some of it less than good-natured, lectures on states' rights. There are more defenders of states' rights on the other side of the aisle in the last 2 days than I have heard in my previous 7 months. The states' rights emanate from the 9th and 10th Amendment. The 9th and 10th Amendments come after the Second Amendment. So the notion that we're going to choose states' rights when we like it and ignore them when we don't, I just find that to be sophistry.
Well, that's what we're suggesting, is the sophistry is bipartisan.
Will the gentleman yield? will the gentleman from Tennessee yield?
Sure, I'll yield. I don't.
I appreciate this exchange very much. It seems to make exactly the point I made yesterday that was so vehemently objected to. The question I asked yesterday of the amendment sponsor
was... The gentleman has yielded an additional minute.
Thank you, Mr. Chairman.
Well,
the gentleman
from South Carolina has the time.
I think the gentleman from Tennessee has the time.
Don't waste your time.
In any event, the question I asked was, if it's eligibility requirements today, then isn't it likely that where we're headed next is the suggestion that there should be no ability for states to impose their own regulations with respect to where the handguns can be carried and how it's actually implemented. The fact is, as I explained, in Florida now, there are all sorts of public places that are open that one can take a concealed handgun. In other states, no. I was told very clearly yesterday, no, it is acceptable for states to regulate those certain aspects, but as to eligibility, there should be a national standard. I think you're suggesting that this is merely a first step and that ultimately the goal is to eliminate any state regulation altogether.
I think you're giving me more credit than I deserve. What I am suggesting is simply this. There would be apoplexy if we required any kind of test for the exercise of any other right, and the Second Amendment is treated as a stepchild in constitutional jurisprudence, and I'm just curious why that is.
The gentleman's time has expired. Mr.